In the name of Allah, it's our class 11th. In the previous topic, we discussed the appointment and the tenure of the Supreme Court judges. Today, we will know the functions of the Supreme Court in India. As we know, the functions of the Supreme Court is it has the power to hear directly some cases which cannot be heard by the other courts within the territory. It has its original jurisdiction in any disputes. Broadly, it can listen the disputes or the petitions which are filed by the persons or the institutions, or the issues which are between the government of India and between the states, one or more states, or it has the jurisdiction to listen or to hear between one or more states whenever any dispute arises between the states. Likewise, it can hear the cases with regard to the fundamental rights. However, High Court can also hear the appeals regarding the fundamental rights. Here, it is its original jurisdiction. Likewise, it is having its appellate jurisdiction. Under its appellate jurisdiction, the Supreme Court is the highest court of appeals within the nation or within the Indian territory. Its writs and decrees run throughout the country. All cases and appeals against the judgment given by the lower courts fall in the appellate jurisdiction of the Supreme Court. Likewise, broadly speaking, it has four types of appellate jurisdiction with which it can hear, which are involving the constitutional, civil, criminal, or such cases which it may grant special leave to appeal. The special leave here we mean under Article 136, the Supreme Court can issue or it has the discretion to grant special leave to appeal from any judgment, decree, determination, sentence, etc., or any order in case of a matter decided by the lower courts within the or tribunals in India. The only exception to this is that the power of judgment is delivered by army tribunals is not under the ambit of the Supreme Court of India. Here it is having another jurisdiction, what we call as the advisory jurisdiction. Under its advisory jurisdiction, the President of India can seek the advice of the Supreme Court in respect of legal matters and disputes of the high public importance. In such cases, the Supreme Court gives its advisory opinion to the President. However, such an advice is not binding upon the President. The President is seeking the advice from the Supreme Court, but it is not binding upon the President. So this is the functioning of the Supreme Courts within the India. Likewise, we have the high courts which are at the state level. The appointment of these judges, the qualifications required by these judges can be discussed as the qualification of the judges of the High Court is as it we have learned in the Supreme Court judges. The qualification is same. The judge should be this resident or should be the citizen of India. Likewise, he must have or he should have been the judge of any high court or any one or more courts for consecutively 10 years for the consecutive 10 years, or he must be an advocate of the High Court or two or more such courts in succession for a period of 10 years, or he must be a distinguished jurist in the opinion or in the eyes of the President of India. The persons possessing such qualifications can be nominated, can be appointed as the High Court judges. However, their tenure, as we know, the tenure of the Supreme Court judges is 65 years, but the tenure of the High Court judges is 62 years. The judges of the High Court can be removed from their office whenever there is a proven charge against him about his incapacity or his dishonesty, or that should be proved, that should be voted within the any house of the parliament by 2/3 majority. When the resolution gets passed, what we call as impeachment, after going through the process of impeachment, these judges can be removed from their office. Either they can resign from their position, or whenever their death occurs, after that they get removed from their office. Likewise, the appointment of these judges is made by the President of India. In case of the Chief Justice of the state, the President consults with the Chief Justice of the India as well as the Governor of the concerned state. In case of other judges, the Chief Justice of India consults the Chief Justice of India and the Chief Justice of the High Court, and likewise he consults the Governor of the state. However, the consultation is not concurrence. Likewise, they are having certain powers. These judges are having certain powers. The original jurisdiction of the High Court is under Article 226. The High Court is empowered to issue writs and orders of habeas corpus, of mandamus, of prohibitions, of quo warranto, or the certiorari, or any of them to a person or authority within its territory for the enforcement of the fundamental rights, or for any other public purpose. The original jurisdiction of the High Court extends to the matters of the admiralty, matrimonials, contempt of court, and cases ordered to be transferred transferred to High Court from the lower courts. Likewise, it has the appellate jurisdiction. Under its appellate jurisdiction, it can hear the appeals of civil cases. In civil cases, if the amount involved in the case should be not at least more than 5,000 rupees, and if any accused is found guilty and has been sentenced for 4 years by the lower courts, that case is being heard by the High Courts also. If the death sentence is avoided by the lower courts to a person, that appeal should be within the consultation of the High Court judges. Likewise, it can hear the cases involving the interpretations of the Constitution or law, or it hears the cases of income tax, as well as it can hear the cases of sales tax, etc. Under its powers of judicial review, it can strike down any law of the state or order of executive, or likewise it can under its advisory jurisdiction, or when it curtails when there is the constitutional disorder, or when it curtails the fundamental freedom of a person. Under its administrative supervision, or under its administrative power, it has the jurisdiction to listen or to hear it as it works as superintendent of the area, of the superintendent of the whole territory, as it whenever there is any kind of all the courts and the tribunals throughout its territory are heard by it, except those which are the arbitrary tribunals. Arbitrary tribunals are the sentences given by the arbitrary tribunals are not heard by the High Court of the state. This is all about the powers, the appointment and the qualification of these High Court judges within India. Thank you. Have a nice day.